Your 2003 tax return. You know what, Barry Joe, I look at it as, and this is kind of creepy, but when they're giving people a check and they get such a good value from it, like for all the freaking anti corruption type stuff I do, I'm like, you get a damn good bargain, state of Oregon or, USA, America. They,
Oh
they get
yeah,
a lot of
yeah.
public service out of people like us. And like, where's
Yeah.
our freaking like award ceremony and ribbon and stuff? You know I respect you. I know you respect me.
Well, as far as it goes.
As far as it goes, gosh. BJS. No, I want to get back to reading this inflammatory Clatsop County blog.
All right, here's what I want to know. Okay,
Okay.
I want to know what that sentence brought up. What'd you get with this?
Oh,
Because
the
this,
the sentence that you just gave me? That was
yeah.
phenomenal. That was utterly phenomenal. It
Well,
brought
good.
me the Code of
What,
Federal
what,
Regulations of the United States of America.
what
Commentary,
did you,
page 485, is now cited in your blog regarding Section 35130, General Prohibitions Against Discrimination. It's the explanatory Google book deal. Then it gave me a cool web blog for a law firm, which I've also copy pasted into your blog because there's Law Cornell, Law Vanderbilt EDU. I don't want to download all these PDFs at this moment. ADA National Network Disability Law Handbook, ADATA.org. I don't know that organization either.
that would be technical assistance.
Technical assistance, yeah, okay. And then the FMG Law. I didn't even really look. I go so fast, Barry. But it was brilliant because it's Freeman, Mathis, and Gary, attorneys at law. I don't know what jurisdiction. They're saying disability or criminal behavior, ADA claims involving law enforcement, February 7th, 2013, by Brian Dempsey. So it's on the Barry Joe blog.
Where do I get to read it?
On your blog named after you, barryjoestull.blogspot.com. I am both webcasting and blogging this phone call, which is why I'm so confused between like 12 tabs on 2 separate browsers, 7 video recordings.
So I can get to sleep tonight. What the fuck? What's this 2013 shit about? What do they say?
Okay, yeah. What? Let's crunch it. Okay. Here we go. Here. Let me have a robot read it to you. I'm gonna have the robot see if you can hear this.
Title II of the Americans with Disabilities Act, ADA, prohibits a public entity from discriminating against a qualified individual with a disability based upon that individual's disability. An individual is deemed to have a disability in the context of the ADA if the individual, 1. has a physical or mental impairment that substantially limits one or more major life activities, 2. has a record of such impairment, or 3. is regarded as having such an impairment. While individual officers will not be held liable under the ADA, counties and municipalities may be held liable for the discriminatory acts of its law enforcement officers if a plaintiff can show that 1. he is a qualified individual with a disability, 2. he was either excluded from participation in or denied the benefits of a public entity's services, programs, or activities, or was otherwise discriminated against by the public entity, and 3. the exclusion, denial of benefit, or discrimination was by reason of the plaintiff's disability. Although application of the ADA to law enforcement activities varies widely from circuit to circuit, claims mainly arise under 3 legal theories. 1. Wrongful arrest. 2. Failure to reasonably accommodate. And 3. Failure to train. The following is a brief discussion of each of these commonly employed legal theories and certain aspects that warrant particular attention. Wrongful arrest. Courts that recognize a wrongful arrest claim under the ADA do so in situations where law enforcement officers have wrongfully arrested a qualified individual with a disability because they misperceive the effects of that disability as criminal activity. In other words, liability may arise where law enforcement officers misconstrue certain actions taken by a qualified individual with a disability as suspicious, illegal, or uncooperative behavior. For example, a person may appear to be intoxicated when she in fact has a disability that causes her to have slurred speech, loss of balance, become lethargic, or become unconscious. Other examples include instances where a person suffering from a seizure may be perceived as being belligerent or disturbing the peace, or where a person who is deaf may appear as uncooperative. However, a wrongful arrest claim under the ADA is not without limits. A disabled individual whose actions were unlawful receives no immunity from arrest due to his disability. For instance, an officer's conduct in attempting to subdue an individual who is suffering from schizophrenia is not a wrongful arrest when the individual threatens the officers with a knife. As a result, probable cause to arrest a qualified individual with a disability will also likely foreclose liability under a wrongful arrest theory. Failure to make reasonable accommodations.
Okay, I'm going to keep reading. Yeah, that's about half of it. Okay, let me keep going a little more.
Yeah, that's great so far.
Okay.
Because I didn't pull a knife.
Under a reasonable accommodations theory, liability is generally imposed where law enforcement officers fail to reasonably accommodate a qualified individual's disability in the course of investigation or arrest, causing the person to suffer greater injury or indignity than other arrestees. For example, arresting, interrogating, or jailing a deaf individual without providing interpretive services may give rise to liability. However, an exception to this theory exists where law enforcement officers are faced with exigent circumstances in the line of duty. Law enforcement officers are not required to make accommodations prior to securing the safety of themselves, other officers, and any nearby civilians. In that light, the ADA would not apply to a law enforcement officer's on-the-street responses, regardless of whether the incident involves subjects with physical or mental disabilities, prior to the officer securing the scene and ensuring that there is no threat to human life. That being said, once the officer has secured the area and the threat to human safety has been eliminated, the officer is under a duty to reasonably accommodate the qualified individual's disability. The 11th Circuit has further limited potential liability under this theory by holding in Burkle v. Miami-Dade County that the duty to provide a reasonable accommodation is not even triggered until a specific demand for an accommodation is made. It is important to note that a wrongful accommodations claim is not limited to the context of arrests, but applies to providing accommodations after arrests, such as during police transportation and subsequent interrogations. For instance, an individual who sustains injuries while being transported in a police vehicle that was not equipped with wheelchair restraints may have an ADA claim. Moreover, liability may also arise for failing to provide reasonable accommodations to disabled inmates in jails and prisons. For example, a county jail may be liable under the ADA for depriving a disabled inmate of a wheelchair. Also, a prisoner who is denied access to certain amenities or programs because of a medical history may have a viable claim under the ADA. Failure to train. An emerging theory of liability under the ADA is based upon a failure to train. Courts have not been entirely consistent in their approach to this claim. In some jurisdictions, liability has been imposed on a county or municipality's failure to train its law enforcement officers for peaceful encounters with disabled persons where such failure necessarily causes discrimination. Some jurisdictions, on the other hand, have failed to directly address whether a failure to train claim is even recognized under the ADA. Courts which recognize such a claim look to the legislative history of the ADA. The House Judiciary Committee stated, in order to comply with the non-discrimination mandate, it is often necessary to provide training to public employees about disability, and such discriminatory treatment based on disability can be avoided by proper training. When enacting the ADA, Congress found that individuals with disabilities continually encounter various forms of discrimination, including failure to make modifications to existing practices. Regulations promulgated by the Department of Justice are also instructive. According to the preamble of the regulations that interpret Title II of the ADA, the general regulatory obligation to modify policies, practices, or procedures requires law enforcement to make changes in policies that result in discriminatory arrests or abuse of individuals with disabilities. Moreover, under 28 CFR Section 35.105, a public entity shall evaluate its current services, policies, and practices that do not or may not meet the requirements of the ADA, and if necessary, the public entity shall proceed to make necessary modifications. And, according to 28 CFR Section 35.130, B. 7, a public entity shall make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making the modifications would fundamentally alter the nature of the service, program, or activity. Courts that decline to recognize a failure to train claim do so by turning to the plain language of the ADA itself. These courts hold that when looking at the plain language, a violation of Title II of the ADA does not occur until there has been an exclusion or denial of participation in, or the benefits of, a public entity's services, which manifestly occurs well after any training of the public entity's agents. Another reason to foreclose such a claim is that acts or omissions involved in failing to train an officer to deal with individuals with disabilities may have a disparate impact on these individuals as a class, but can never by itself equate to a specific act of intentional discrimination against a particular individual. Conclusion: while it would be unreasonable to expect law enforcement officers to diagnose or recognize every disability, to avoid potential liability, officers should make an effort to distinguish between the effects of a disability from criminal behavior. Moreover, law enforcement officers should be cognizant that unless they are faced with exigent circumstances entailing a necessity to secure the scene or eliminate a threat of harm, they have a duty to provide reasonable accommodations to a qualified individual with a disability. Lastly, although jurisdictions are not uniform, counties and municipalities should consider incorporating the requirements and objectives of the ADA in training materials and to modify policies, if necessary, to guide officers' interactions with disabled individuals.
Oh my gosh, isn't that magnificent?
So where do you want to start?
What's that?
You said it's magnificent. Where do you want to start?
I was thinking I should just send it to Ted Wheeler.
Okay, so what was the case? Miami what?
Oh, the name of
Vita B versus Miami.
Okay, Bercoli. Bircoll, Bircoll versus V. Miami / Dade County. Good point. Good point.
Let me see if I got it. I might have that. What's it called again? B.
Bercoli.
Bercoli.
Yeah, Miami-Dade. Yeah, let's see. Bircol, Bircol. Is that what I said? Bircol. Yeah, it's just really small font. That's why my eyes are not reading it. Okay, V. Miami - Dade. Bircol v. Miami. Oh, cool. Here it is. Okay, I've got it. Court listener, case law, fine law, media CA, disabled rights law. Cool. 4 pages of results. That's good. Court opinions, Court of Appeals. Yeah. Barry, are you getting tired? You don't ever get tired. You study hard.
What?
I'm getting tired. It's like normally I would have had a cup of tea or two by now. I had some oatmeal earlier.
You know, my buddy came over and took all the buckets of bike parts, the kitty litter buckets of bike parts that were stacked in my kitchen for about a week.
Uh-huh.
And he stacked them in my bedroom, and I don't think it matters.
Yeah. You just.
And I looked over on my kitchen table, which I kind of have a kitchen table now. I don't have buckets in the way. And I saw I had some chili, and I was like, oh yeah, that's why I made that rice earlier.
Eating, yes.
No, I didn't know about that. I didn't know I had the chili, but yeah, I made rice earlier. See,
that sounds good.
I'm gonna sneak up on food.
Oh, are you doing that thing again?
Well, what thing? Yeah, it's just part of my disease is that I have nausea, and part of nausea is nausea is like the next door neighbor to vomiting. So I rarely hurl. I just feel like it, and so it's an interesting disease.
Oh my God.
Just that. Because
you know what I'm feeling right now? I just had a conversion. I had like an emotional conversion of feeling sorry for Clatsop County's problems. I mean, it's not like I don't already feel sorry for them. I definitely do. I'm not trying to be a problem to them. But this case is so intriguing, and I want to find the current disposition of it. And all I could find were his appeals on Google Scholar.
this guy has a second appeal, is that what you're talking about?
Yeah, he's on his third appeal. He basically kept ruling about hearsay. Gosh. Yeah, so I just put it on my blog. I can tell you what's the deal. So his latest thing in 2016, he basically he maintains his innocence, but he acted strange in trial according to this Viewpoint blog. Like he was laughing at inappropriate times and staring at the jury. You know, it's like Clatsop County. God, I can't describe it. Think like Twilight Zone meets 1950s meets a sprinkling of cool people, and like Twilight Zone, it's more like old Portland, honestly, in a certain ways. Like it'll become as crazy as you guys have become. Let's see. Old Portland, like 15 years ago or something. But like this is the bastion of the KKK, was Astoria. So it's still just like it's super like backwards, like from generations. Plus it's a bunch of like basically illiterate Scandinavian immigrant hardworking people who drank themselves to death and like lived for fish and logging. And like I even heard that Old Town Astoria was split between the Finnish side, the Swedish side, and the Norwegian side, where there were like Scandinavian, I guess you call it a ghetto, maybe. So there's his 2014 appeal. So I've got him on the top of brain garbage at the moment. His 2016 appeal, it's just a horrifying case. I mean, it's so upsetting. He was convicted by a jury of 12 counts of first-degree sexual abuse and first-degree sodomy against a child victim. So he assigns errors to the trial court's admission pursuant to OEC 803 of certain hearsay statements of the victim. I think they were trying to protect the child by just entering her statement into the record. I don't know that, but so they've got this technicality of they had a mistrial. On the second trial, they forgot to read the hearsay statement. And then they're just like, well, we read it in 2007. We're just having a retrial. We already read it, so it's applicable. So they're basically arguing on this technicality of hearsay evidence. The hearsay statements were admitted at trial, and the defendant was convicted by a jury of 12 counts of first-degree sodomy and 12 counts of first-degree sexual abuse on his granddaughter, okay? We reversed defendant's convictions on evidentiary grounds not currently at issue. Following that reversal, the case was set for a new trial after several continuances. Defendant's retrial started February 12, 2013. Before that retrial, the state did not refile a notice of its intent to introduce the victim's hearsay statements at trial or otherwise transmit a new copy of the May 2007 notice to defendant. So the latest thing, okay, that I think maybe I actually did put this. Okay, here it is. The latest article, unbelievable. This is still dragging on. April 25th, 2019. District Attorney Ron Brown and Circuit Court Judge Cindy Matias will prosecute and hear the case against Thomas Kelly, who was twice convicted of sexually abusing a family member, for a third time. So for a third time, they will hear the case. Okay. So, boy, that sentence is a little confusing. Defense motions that requested Brown and Matias be removed from the case based on concerns over fairness were denied this week by Multnomah County Senior Circuit Court Judge Julie Franz. I was happy to see it upheld, Brown said. In 2008, a jury convicted the Astoria man of 12 counts of first-degree sodomy and 12 counts of first-degree sexual abuse for ongoing abuse of the 9-year-old family member between July 2004 and May 2006. He was sentenced to more than 33 years in prison. An Oregon Supreme Court decision in 2010 held that medical experts cannot testify about child sex abuse diagnoses if no physical evidence exists. As a result, Dr. Roy Little's testimony, which did not contain physical evidence, was deemed invalid. The Oregon Court of Appeals overturned Kelly's conviction in 2011 and ordered that Clatsop County Circuit Court schedule a new trial. Kelly was retried in 2013 and was again convicted of 24 counts of sexual abuse and sodomy. The conviction on the retried case was possibly due to the victim's testimony and DNA evidence found where the abuse took place, Brown said. Oregon Supreme Court upheld the conviction in 2016. But last year, Kelly filed another appeal in Umatilla County where he argued his lawyer should have objected to a line of questioning from Brown that enabled a witness giving inadmissible testimony. The judge sent the case back to Clatsop County Circuit Court, and Kelly was released on bail. Wow, I didn't. Oh, yeah, okay, he's been released. The defense had argued that Brown, in a line of questioning, disregarded previous case law by asking Little whether the victim had been coached. Okay, the Multnomah County judge assigned to hear the dispute found that while Brown eliciting the inadmissible testimony created error, it was not done with the intent to deny the defendant a fair trial. The defense also argued that Brown has a delusional view of the state's evidence and lacks the ability to objectively assess the case. These claims are also dismissed given that the reason for the reversal of the original case was not based on ethical issues but rather the changes in the law that prohibited sexual abuse diagnosis without physical findings. The defense also claimed Brown showed his bias toward Kelly by using words like evil and despicable in his closing statement. Judge Franz found his language summarized the defendant's acts that were strongly supported by the evidence and were not used because of personal prejudice or bias. There's nothing to indicate that the prosecuting attorney harbored any bias against the defendant as an individual, but rather that it's the defendant's criminal acts that fueled his concerted effort to obtain a conviction, Franz found. A hearing to set the new trial expected to be scheduled sometime next month, Brown said, and I don't know the disposition of that, but now that I come to think of it, that was a tangent for me because there is a different case I'm trying to, that I think, there's another Ron Brown case that is under discussion. The poor guy, man, like, it's like I totally forgive him for being pretty abrupt on the phone with me today. But there is another Ron Brown sex abuse case that is also maybe like a headline thing. Well, that was... oh, God. Poor thing. There's a district attorney and a criminal by that man. So, okay. Wow. It was more of a horrific child torture type case, if I remember. Child torture? They would never say that. Sex abuse. It was to do with parents, and this is the one that I think I walked in on. Child sexual abuse accommodation syndrome. Have you heard of that?
What is it?
Oh no. Oh no. I think I found something. This is child victims of sexual abuse face secondary trauma in the crisis of discovery. Their attempts to reconcile their private experiences. Okay, so they're basically saying the child sexual abuse accommodation syndrome. He's trying to create a disorder that describes a phenomenon like helplessness, secrecy, entrapment, delay. Oh, this is kind of brilliant. It's describing the victim pathology that leads prosecutors and whomever to having a hard time to understand why victims behave the way they do. Okay, I'm stopping this